Chapter 3, Part 5 of an Essay on the Trial by Jury. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Beth Ann. Trial by Jury by Lysander Spooner. Chapter 3, Part 5. Section 4. The right of juries to fix the sentence. The nature of the common law courts existing prior to Magna Carta, such as the county courts, the hundred courts, the court leet, and the court baron, all prove what has already been proved from Magna Carta, that, in jury trials, the juries fixed the sentence. Because in those courts there was no one but the jury who could fix it, unless it were the sheriff, bailiff, or steward, and no one will pretend that it was fixed by them. The juries unquestionably gave the judgment in both civil and criminal cases. That the juries were to fix the sentence under Magna Carta is also shown by statutes subsequent to Magna Carta. A statute passed 51 years after Magna Carta says that a baker, for default in the weight of his bread, debeat amatiari vel subire judicium pillorie, that is, ought to be immersed or suffer the sentence of the pillory; and that a brewer, for selling ale contrary to the assize, debeat amatiari vel pati judicium tumbrelli, that is, ought to be immersed or suffer judgment of the tumbrel. 51 Henry III, Statute 6, 1266. If the king, the legislative power, had had authority to fix the punishments of these offenses imperatively, he would naturally have said these offenders shall be immersed, and shall suffer judgment of the pillory and tumbrel, instead of thus simply expressing the opinion that they ought to be punished in that manner. The Statute of Westminster, passed 60 years after Magna Carta, provides that no city, borough, nor town, nor any man be immersed without reasonable cause, and according to the quantity of the trespass; that is to say, every freeman saving his freehold, and a merchant saving his merchandise, a villein his wainage, and that by his, or their, peers. 3 Edward I, Chapter 6, 1275. The same statute, Chapter 18, provides further that, forasmuch as the common fine and immersement of the whole county and ire of the justices for false judgments, or for other trespass, is unjustly assessed by sheriffs and berators in the shires, so that the sum is many times increased, and the parcels otherwise assessed than they ought to be, to the damage of the people, which be many times paid to the sheriffs and berators, which do not acquit the payers, it is provided, and the king wills, that from henceforth such sums shall be assessed before the justices in ire, afore their departure, by the oath of knights and other honest men, upon all such as ought to pay; and the justices shall cause the parcels to be put into their estreats, which shall be delivered up unto the exchequer, and not the whole sum. Statute 3, Edward I, Chapter 18, 1275. Note: Coke, as late as 1588, admits that immersements must be fixed by the peers. 8 Coke's Rep. 38, 2nd Institutes 27. But he attempts, wholly without success, as it seems to me, to show a difference between fines and immersements. The statutes are very numerous, running through the 300 or 400 years immediately succeeding Magna Carta, in which fines, ransoms, and immersements are spoken of as if they were the common punishments of offenses, and as if they all meant the same thing. If, however, any technical difference could be made out between them, there is clearly none in principle, and the word amercement, as used in Magna Carta, must be taken in its most comprehensive sense. The following statute, passed in 1341, 125 years after Magna Carta, providing for the trial of peers of the realm, and the king's ministers, contains a recognition of the principle of Magna Carta, that the jury are to fix the sentence. Whereas before this time the peers of the land have been arrested and imprisoned, and their temporalities, lands, and tenements, goods, and cattles, seized into the king's hands, and some put to death without judgment of their peers, it is accorded and assented that no peer of the land, officer, nor other, because of his office, nor of things touching his office, nor by any other cause, shall be brought in judgment to lose his temporalities, lands, tenements, goods, and cattles, nor to be arrested, nor imprisoned, outlawed, exiled, nor forjudged, nor put to answer, nor be judged, but by award (sentence) of the said peers in Parliament. 15 Edward III, Statute 1, Section 2. Section 4 of the same statute provides, that in every Parliament, at the third day of every Parliament, the king shall take in his hands the offices of all the ministers aforesaid, that is, the chancellor, treasurer, barons, and chancellor of the exchequer, the justices of the one bench and of the other, justices assigned to the country, steward and chamberlain of the king's house, keeper of the privy seal, treasurer of the wardrobe, controllers, and they that be chief deputed to abide nigh the king's son, Duke of Cornwall. And so they shall abide 4 or 5 days, except the offices of justices of the one place or the other, justices assigned, barons of exchequer. So always that they and all other ministers be put to answer to every complaint, and if default be found in any of the said ministers, by complaint or other manner, and of that attained in Parliament, he shall be punished by judgment of the peers, and put out of his office, and another convenient put in his place. And upon the same our sovereign lord the king shall do cause to be pronounced and made execution without delay, according to the judgment (sentence) of the said peers in the Parliament. Here is an admission that the peers were to fix the sentence or judgment, and the king promises to make execution according to that sentence. And this appears to be the law, under which peers of the realm and the great officers of the crown were tried and sentenced, for 400 years after its passage, and, for aught I know, until this day. The first case given in Hargrave's collection of English state trials is that of Alexander Neville, Archbishop of York, Robert Vere, Duke of Ireland, Michael de la Pole, Earl of Suffolk, and Robert Tresilian, Lord Chief Justice of England, with several others, convicted of treason, before the Lords of Parliament, in 1388. The sentence in these cases were adjudged by the Lords of Parliament in the following terms, as they are reported: Wherefore the said Lords of Parliament, there present, as judges in Parliament, in this case, by assent of the king, pronounced their sentence, and did adjudge the said Archbishop, Duke, and Earl, with Robert Tresilian, so appealed, as aforesaid to be guilty, and convicted of treason, and to be drawn and hanged, as traitors and enemies to the king and kingdom, and that their heirs should be disinherited forever, and their land and tenements, goods and chattels, forfeited to the king, and that the temporalities of the Archbishop of York should be taken into the king's hands. Also in the same case, Sir John Holt, Sir William Burr, Sir John Carey, Sir Roger Fulthorpe, and John Lockton, were by the Lords Temporal, by the assent of the king, adjudged to be drawn and hanged, as traitors, their heirs disinherited, and their lands and tenements, goods and chattels, to be forfeited to the king. Also, in the same case, John Blake, of counsel for the king, and Thomas Usk, under sheriff of Middlesex, having been convicted of treason, the lords awarded by assent of the king, that they should both be hanged and drawn as traitors, as open enemies to the king and kingdom, and their heirs disinherited for ever, and their lands and tenements, goods and chattels, forfeited to the king. Also, Simon Burleigh, the king's chamberlain, being convicted of treason, by joint consent of the king and lords, sentence was pronounced against the said Simon Burleigh, that he should be drawn from the town to Tyburn, and there be hanged till he be dead, and then have his head struck from his body. Also, John Beauchamp, steward of the household to the king, James Beaureverse, and John Salisbury, knights, gentlemen of the privy chamber, were in like manner condemned. First Hargrave's State Trials, first case. Here the sentences were all affixed by the peers, with the assent of the king. But that the king should be consulted and his assent obtained to the sentence pronounced by the peers, does not imply any deficiency of the power on their part to fix the sentence independently of the king. There are obvious reasons why they might choose to consult the king, and obtain his approbation of the sentence they were about to impose, without supposing any legal necessity for their so doing. So far as we can gather from the reports of state trials, peers of the realm were usually sentenced by those who tried them, with the assent of the king. But in some instances no mention is made of the assent of the king, as in the case of Lionel, Earl of Middlesex, Lord High Treasurer of England, in 1624, 400 years after Magna Carta, where the sentence was as follows: This High Court of Parliament doth adjudge that Lionel, Earl of Middlesex, now Lord Treasurer of England, shall lose all his offices which he holds in this kingdom, and shall, hereafter, be made incapable of any office, place, or employment in the state and commonwealth; that he shall be imprisoned in the Tower of London during the king's pleasure; that he shall pay unto our sovereign lord the king a fine of £50,000; that he shall never sit in Parliament any more, and that he shall never come within the verge of the court. 2 Howell's State Trials, 1250. Here was a peer of the realm, and a minister of the king, of the highest grade; and if it were ever necessary to obtain the assent of the king to sentences pronounced by the peers, it would unquestionably have been obtained in this instance, and his assent would have appeared in the sentence. Lord Bacon was sentenced by the House of Lords, 1620, no mention being made of the assent of the king. The sentence is in these words: And, therefore, this High Court doth adjudge that the Lord Viscount St. Albans, Lord Chancellor of England, shall undergo fine and ransom of £40,000, that he shall be imprisoned in the Tower during the king's pleasure; that he shall forever be incapable of any office, place, or employment in the state or commonwealth; that he shall never sit in Parliament, nor come within the verge of the court. And when it was demanded of him before sentence, whether it were his hand that was subscribed to his confession, and whether he would stand to it, he made the following answer, which implies that the lords were the ones to determine his sentence: My lords, it is my act, my hand, my heart. I beseech your lordships to be merciful to a broken reed. 1 Hargrave's State Trials, 386-7. The sentence against Charles I, 1648, after reciting the grounds of his condemnation, concludes in this form: For all which treasons and crimes, this court doth adjudge, that he, the said Charles Stuart, as a tyrant, traitor, murderer, and public enemy to the good people of this nation, shall be put to death by the severing his head from his body. The report then adds: "This sentence being read, the President of the court spake as followeth: This sentence now read and published is the act, sentence, judgment, and resolution of the whole court." 1 Hargrave's State Trials, 1037. Unless it had been the received law of the land that those who tried a man should fix his sentence, it would have required an act of Parliament to fix the sentence of Charles, and his sentence would have been declared to be the sentence of the law, instead of the act, sentence, judgment, and resolution of the court. But the report of the proceedings in the trial of Thomas, Earl of Macclesfield, Lord High Chancellor of Great Britain, before the House of Lords, for high crimes and misdemeanors in the execution of his office, in 1725, is so full on this point, and shows so clearly that it rested wholly with the Lords to fix the sentence, and that the assent of the king was wholly unnecessary, that I give the report somewhat at length. After being found guilty, the Earl addressed the Lords, for mitigation of sentence, as follows: "I am now to expect your lordship's judgment, and I hope that you will be pleased to consider that I have suffered no small matter already in the trial, in the expense I have been at, the fatigue, and what I have suffered other ways. I have paid back £10,800 of the money already. I have lost my office. I have undergone the censure of both houses of Parliament, which is in itself a severe punishment," etc., etc. On being interrupted, he proceeded: "My lordships, I submit whether this be not proper in mitigation of your lordships' sentence; but whether it be or not, I leave myself to your lordships' justice and mercy. I am sure neither of them will be wanting, and I entirely submit." Then the said Earl, as also the managers, were directed to withdraw, and the House of Lords ordered Thomas, Earl of Macclesfield, to be committed to the custody of the gentleman usher of the Black Rod, and then proceeded to the consideration of what judgment, that is, sentence, for he had already been found guilty, to give upon the impeachment against the said Earl. The next day, the Commons, with their Speaker, being present at the bar of the House of Lords, the Speaker of the House of Commons said as follows: "My lords, the knights, citizens, and burgesses in Parliament assembled, in the name of themselves and of all the Commons of Great Britain, did at this bar impeach Thomas, Earl of Macclesfield, of high crimes and misdemeanors, and did exhibit articles of impeachment against him, and have made good their charge. I do, therefore, in the name of the knights, citizens, and burgesses in Parliament assembled, and of all the Commons of Great Britain, demand judgment (sentence) of your lordships against Thomas, Earl of Macclesfield, for the said high crimes and misdemeanors." Then the Lord Chief Justice King, Speaker of the House of Lords, said: "Mr. Speaker, the Lords are now ready to proceed to judgment in the case by you mentioned. Thomas, Earl of Macclesfield, the Lords have unanimously found you guilty of high crimes and misdemeanors, charged on you by the impeachment of the House of Commons, and do now, according to law, proceed to judgment against you, which I am ordered to pronounce. Their lordships' judgment is, and this high court doth adjudge, that you, Thomas, Earl of Macclesfield, be fined in the sum of £30,000 unto our sovereign lord the king, and that you shall be imprisoned in the Tower of London, and there kept in safe custody until you shall pay the said fine." 6 Hargrave's State Trials, 762, 3 and 4. This case shows that the principle of Magna Carta, that a man should be sentenced only by his peers, was in force and acted upon as law in England so lately as 1725, 500 years after Magna Carta, so far as it applied to a peer of the realm. But the same principle on this point that applies to a peer of the realm applies to every freeman. The only difference between the two is, that the peers of the realm have had influence enough to preserve their constitutional rights, while the constitutional rights of the people have been trampled upon and rendered obsolete by the usurpation and corruption of the government and the courts. Section 5. The Oaths of Judges. As further proof that the legislation of the king, whether enacted with or without the assent and advice of his parliament, was of no authority unless it were consistent with the common law, and unless juries and judges saw fit to enforce it, it may be mentioned that it is probable that no judge in England was ever sworn to observe the laws enacted, either by the king alone, or by the king with the advice and assent of parliament. The judges were sworn to "do equal law and execution of right to all the king's subjects, rich and poor, without having regard to any person, and that they will deny no man common right." Note: Common right was the common law. 1 Coke's Institutes, 142a, 2 ditto, 55-6. But they were not sworn to obey or execute any statutes of the king, or of the king and parliament. Indeed, they were virtually sworn not to obey any statutes that are against the common right, or contrary to the common law, or law of the land, but to certify the king thereof; that is, notify him that his statutes are against the common law, and then proceed to execute the common law, notwithstanding such legislation to the contrary. The words of the oath on this point are these: "That ye deny no man common right by virtue of the king's letters, nor none other man's, nor for none other cause; and in case any letters come to you contrary to the law, that is, the common law, as will be seen on reference to the entire oath given in the note, that ye do nothing by such letters, but certify the king thereof, and proceed to execute the law, that is, the common law, notwithstanding the same letters." When it is considered that the king was the sole legislative power, and that he exercised his power to a great extent, by orders in council, and by writs and letters, addressed oftentimes to the sheriff and other person, and that his commands, when communicated to his justices, or any other person, by letters, or writs, under seal, had as much legal authority as laws promulgated in any other form whatever, it will be seen that this oath of the justices absolutely required that they disregard any legislation that was contrary to common right, or the common law, and notify the king that it was contrary to common right, or the common law, and proceed to execute the common law, notwithstanding such legislation. Note: The oath of the justices is in these words: "Ye shall swear that well and lawfully ye shall serve our lord the king, and his people, in the office of justice; and that lawfully ye shall counsel the king in his business; and that ye shall not counsel nor assent to anything which may turn him in damage or desertion in any manner, way, or color; and that ye shall not know the damage or desertion of him, whereof ye shall not cause him to be warned by yourself or by other; and that ye shall do equal law and execution of right to all his subjects, rich and poor, without having any regard to any person; and that ye shall take not by yourself, or by other, privily nor apertly, gift, nor reward of gold nor silver, nor of any other thing that may turn to your profit, unless it be meat or drink, and that of small value, of any man that shall have any plea or process hanging before you, as long as the same process shall be so hanging, nor after for the same cause; and that ye take no fee, as long as ye shall be justice, nor robe of any man, great or small, but of the king himself; and that ye give none advice or counsel to no man, great or small, in no cause where the king is party; and in case that any, of what estate or condition they be, come before you in your sessions with force and arms, or otherwise against the peace, or against the form of the statute thereof made, to disturb execution of the common law, (mark the term common law,) or to menace the people that they may not pursue the law, that ye shall cause their bodies to be arrested and put in prison; and in case they be such that ye cannot arrest them, that ye certify the king of their names and of their misprision, hastily, so that he may ordain a convenable remedy; and that ye by yourself, nor by other, privily nor pertly, maintain any plea or quarrel hanging in the king's court, or elsewhere in the country; and that ye deny no man common right by the king's letters, nor none other man's, nor for none other cause; and in case any letters come to you contrary to the law, that is, the common law, before mentioned, that ye do nothing by such letters, but certify the king thereof, and proceed to execute the law, the common law, before mentioned, notwithstanding the same letters; and that ye shall do and procure the profit of the king and his crown, with all things where ye may reasonably do the same; and in case ye be from henceforth found in default in any of the points aforesaid, ye shall be at the king's will of body, lands, and goods, thereof to be done as shall please him, as God you help, and all saints. 18 Edward III, Statute 4, 1344. If there could be any doubt that such was the meaning of this oath, that doubt would be removed by a statute passed by the king 2 years afterwards, which fully explains this oath, as follows: "Edward, by the grace of God, etc., to the Sheriff of Stafford, greeting. Because that by divers complaints made to us, we have perceived that the law of the land, which we by our oath are bound to maintain, is the less well kept, and the execution of the same disturbed many times by maintenance and procurement, as well in the court as in the country, we, greatly moved of conscience in this matter, and for this cause, desiring as much for the pleasure of God and ease and quietness of our subjects, as to save our conscience, and for to save and keep our said oath, by the assent of the great men and other wise men of our council, we have ordained these things following: First, we have commanded all our justices, that they shall from henceforth do equal law and execution of right to all our subjects, rich and poor, without having regard to any person, and without omitting to do right for any letters or commandment which may come to them from us, or from any other, or by any other cause; and if that any letters, writs, or commandments come to the justices, or to other deputed to do law and right according to the usage of the realm, in disturbance of the law, or of the execution of the same, or of right to the parties, the justices and others aforesaid shall proceed and hold their courts and processes, where the pleas and matters be depending before them, as if no such letters, writs, or commandments were come to them; and they shall certify us and our council of such commandments, which be contrary to the law, that is, the law of the land, or common law, as afore is said. Note: That the terms law and right, as used in this statute, mean the common law, is shown by the preamble, which declares the motive of the statute to be that "the law of the land, the common law, which we, the king, by our oath are bound to maintain, may be the better kept," etc. And to the intent that our justices shall do even right to all people in the manner aforesaid, without more favor showing to one than to another, we have ordained and caused our said justices to be sworn, that they shall not from henceforth, as long as they shall be in the office of justice, take fee nor robe of any man, but of ourself; and that they shall take no gift, nor reward by themselves, nor by other, privily nor pertly, of any man that hath to do before them by any way except meat and drink, and that of small value; and that they shall give no counsel to great men or small, in case where we be party, or which do or may touch us in any point, upon pain to be at our will, body, lands, and goods, to do thereof as shall please us, in case they do contrary. And for this cause we have increased the fees of the same, our justices, in such manner as it ought reasonably to suffice them. 20 Edward III, chapter 1, 1346. Other statutes of similar tenor have been enacted, as follows: It is accorded and established, that it shall not be commanded by the great seal, nor the little seal, to disturb or delay common right; and though such commandments do come, the justices shall not therefore omit, to do right in any point. Statute 2, Edward III, chapter 8, 1328. That by commandment of the great seal, or privy seal, no point of this statute shall be put in delay; nor that the justices of whatsoever place it be shall omit, to do the common law, by commandment, which shall come to them under the great seal, or the privy seal. 14 Edward III, statute 1, chapter 14, 1340. It is ordained and established, that neither letters of the signet, nor the king's privy seal, shall be from henceforth sent in damage or prejudice of the realm, nor in disturbance of the law, the common law. 11 Richard II, chapter 10, 1387. It is perfectly apparent from these statutes, and from the oath administered to the justices, that it was a matter freely confessed by the king himself, that his statutes were of no validity if contrary to the common law, or common right. The oath of the justices, before given, is, I presume, the same that has been administered to judges in England from the day when it was first prescribed to them, 1344, until now. I do not find from the English statutes that the oath has ever been changed. The essay on grand juries, before referred to, and supposed to have been written by Lord Somers, mentions this oath, p. 73, as being still administered to judges, that is, in the time of Charles II, more than 300 years after the oath was first ordained. If the oath has never been changed, it follows that judges have not only never been sworn to support any statutes whatever of the king, or of Parliament, but that, for 500 years past, they actually have been sworn to treat as invalid all statutes that were contrary to the common law. End of chapter 3, part 5.